South Africa can't harbour foreigners accused of human rights abuses. A court ruling's confirmed that international law obliges the country to investigate allegations of atrocities if the accused cross our borders. The NPA has been ordered to investigate and prosecute high-level Zimbabwean officials if they enter South Africa.
South Africa will not be a safe haven for international leaders and officials trying to dodge prosecution for their crimes. High Court Judge Hans Fabricius has ruled that crimes against humanity committed in Zimbabwe should be investigated here. That's if and when those responsible set foot in the country. Human rights activists approached the court after the NPA and SAPS failed to investigate allegations that MDC supporters were tortured by ZANU-PF officials prior to Zimbabwe's 2008 elections. At the time, the NPA defended its decision, saying arresting the officials who were frequently visiting South Africa would hamper mediation efforts in Zimbabwe. The ruling has been welcomed by human rights groups.
It is actually a triumph for the victims of torture. It is a triumph of the rule of law, of our political considerations, and we are very, very happy about it.
The judgment will also force South African authorities to charge other international officials allegedly responsible for atrocities in their respective countries under the Rome Statute. However, the NPA says it is not responsible for investigation of cases and will study judgment before deciding whether to appeal. Narissa Subramani, E-News, Pretoria.
And that's exactly what the NPA told us a little earlier, saying that it's mostly up to police to investigate and that they were there to offer, the NPA that is, offer guidance and I think the word assistance was the word that the spokesperson used. Well, let's give you another perspective now. The Executive Director of the Southern Africa Litigation Centre, Nicole Fritz, good evening to you and a very warm welcome. Before we get to the NPA's response to this judgment today, is it surprising?
Well, it wasn't surprising given the way the hearing went. We had a judge who seemed very receptive to the arguments made by ourselves in the court, at one point saying to the respondents, isn't this application good unto itself, quoting Kant, saying it ensures that those who are voiceless, who are unable to secure justice in their own country, have their voices heard here in South Africa.
Is there international precedent for a judgment like this?
Well, there is international precedent. So we have seen cases along the lines of the famous Pinochet case in the United Kingdom. We've seen Canadian cases of this kind. But I think it's the first case on the African continent where we've seen domestic processes, the domestic legal system used in order to uphold international law obligations.
Is the decision, the judgment, not academic, though? How many of those alleged perpetrators actually find themselves in South Africa?
Well, it's surprising. We name 18 perpetrators in our dossier. The National Prosecuting Authorities enlisted individuals to undertake an examination of our dossier after the event, after they had said, in fact, that they would not investigate and prosecute. And just from those preliminary investigations, they were able to establish that 8 of those individuals had, in fact, entered South Africa during the period under question.
And what are these 18 alleged to have done?
These 18 individuals are alleged to have orchestrated the torture. So they were either directly involved in that they carried out the torture, or they were in positions of command responsibility. So they, in effect, ordered the torture to happen.
Do you believe that police, and for that matter the NPA, actually have the appetite to follow through with a thorough and robust investigation?
Well, the response to our dossier was such that they do not seem to have the appetite. They did not seem to understand their obligations under the Rome Statute and under South Africa's own domestic law. But the judgment is very detailed, the order is very detailed. It gives content to those obligations. It makes it clear what they will have to do. And we believe that within the framework of this order, a credible investigation can be carried out.
What do you make of the NPA insisting that it's not responsible for investigating the cases, that it's there to assist and offer guidance, then it's entirely up to the police to do it? Is that passing the buck?
That's worrying. I think they need to study the judgment. It's clear in the law that the Priority Crimes Litigation Unit, which is a unit within the prosecuting authority, is in fact entrusted with managing and directing the investigations and prosecutions of these types of crimes. So very significantly, they look to for leadership and direction and management of these crimes.
How difficult is it going to be to conduct a credible investigation into these alleged crimes, given that compliance is going to be non-existent and it's going to be very difficult often to interview witnesses?
Well, our position is that it's not going to be too difficult to interview the witnesses. We've got our dossier contains numerous affidavits of those who were tortured, who have indicated that they would be available for further questioning. There is corroborating in South Africa. They would come. Some of them are in South Africa, and those in Zimbabwe would be willing to come into South Africa. There is corroborating evidence from medical experts and from family members. All of those individuals would be willing to make their documentation, their evidence available. And I should say this is not unknown. If you look at the investigations that have happened before the Rwanda Tribunal, the Yugoslav Tribunal, going on before the International Criminal Court, you don't necessarily have the cooperation of the state in which the investigations are happening, and yet credible investigations and prosecutions have taken place.
How would you like then to see the NPA acting, as well as the police, with immediate effect? I mean, given that they've got to study the judgment first.
Well, immediately that they must comply with that order, that they must now open a docket, that they must engage with us, they must seek to interview the witnesses that we have said we will help make available, and that's how they must now.
Is there one single priority case that they need to be focusing on?
Well, our dossier relates to several instances of torture, but they relate to a single event, the arrest, the raid on Harvest House, and the arrest and detention and subsequent torture of individuals, and we believe that's the case that must be pursued.
And given how sensitive this is, there's absolutely no doubt it's going to cause serious diplomatic tensions. Again, does Pretoria have the appetite for this, or is this something that they're likely to shy away from?
Well, it's interesting.
I mean, again, also, how do you balance the two?
Sure. And I think that this is a question that is always held up. It's interesting that Lindiwe Sisulu, who's leading the mediation efforts, has just said that she doesn't believe that these will compromise the mediation efforts. But I would also say that if you look to history, it's not that such that international criminal justice proceedings imperil peace negotiations. In fact, often they support them. So in the case of Yugoslavia, when indictments were issued against Milosevic and Karadzic, meant that they weren't able to participate in peace negotiations, and credible peace negotiations then resulted. I think what this order might do is require the hardliners in Zimbabwe to engage seriously with their counterparts in Zimbabwe. This judgment doesn't have application in Zimbabwe, and to secure peace there.
By the argument, some would say that's very idealistic, though. But I suppose you're not going to achieve this without any sort of idealism.
I think that that's true, and ultimately we have a court order that upholds South Africa's responsibilities as a credible, responsible member of the international community, and ultimately the notion of international justice is premised on that.
Do you expect the NPA to appeal?
The likelihood is that they will appeal. So yes, we are expecting an appeal.
Thank you very much for joining us, and Nicole Fritz with us, the Executive Director of the Southern Africa Litigation Centre.